Hello everyone, my name is Anirudh and today's topic is copyright ownership for an extempore performance under Indian copyright law. With this, let's start with the video. If a singer at a concert was to sing in a melodious way in an impromptu manner, that is, there was no prior existing lyrics or melody, would such a singer be considered an author of the lyrics and the music apart from being a performer? Interestingly, a lot of thought has been put into such a situation or any other situation of similar kind where a performer, say a singer, choreographer or a stand-up comedian is creating a work on the spot through his or her performance. But none of their positions render them authorship in their extempore creation if it is not prior fixed in a tangible medium. While such extempore performances may be able to pass the qualifier of originality easily, the issue arises in not being able to meet the criteria of fixation. Let's understand interrelationship between performer, performance and a work. If you look at the definition of performer and a performance, we can see that they are closely linked with each other, but there doesn't exist any link between a work and a performance. Work and a performance under copyright law are two separate concepts. Through the conventional understanding of performance is that a performance has to be linked with work. This raises a question as to such performances where there is no pre-existing work. Thus, this leads to an interpretation that there exists a linkage between work and performance, which means if a performer is not performing a work, it will not be considered a performance. As per this interpretation, any stage performance of impromptu nature that is not performing a pre-existing work will not be considered a performance, and no performer's rights would vest in the artist of such impromptu performance. But wouldn't that be wrong to such a singer in terms of his rights under the Copyright Act? Fortunately, the Indian Copyright Act has taken a very progressive interpretation in this regard by not creating any linkage between a performance and a work. This makes it clear that a singer performing in an extempore manner without relying on any pre-existing work can very well create a work while performing, and in that case, he shall be both an author and a performer of such work, entitled to copyright as well as performer's rights respectively. Moving forward, a singer, an author of music and lyrics. Section 2(p) of the Copyright Act defines a musical work as a work consisting of music but does not include any words or actions intended to be sung, spoken or performed with music. Thus, in the context of copyright law, there are two kinds of works that shall come into question. First, music, which falls in the category of musical works, and second, lyrics, which fall in the category of literary works. We need to look at fixation in musical work. The definition of composer under Section 2 FFA uses a terminology regardless of whether he records it, which clearly suggests that the Act does not mandate the requirement of fixation with respect to musical works. Hence, he can rightfully claim his authorship over such music. Now, let's understand fixation of literary work. Intuitively, a literary work is always required to be fixed and cannot be perceived without it being reduced in a tangible medium. However, if we take this understanding, then lyrics would also require some kind of fixation prior to it being performed. But this becomes problematic when we consider Section 14(a)(3), which states in case of a literary dramatic work to perform the work in public. This shows that the Copyright Act recognized that a literary work can also be performed, or rather it can facilitate performance. Further, if we look at Section 2(a)(2), it says adaptation means in relation to a literary work, the conversion of the work into a dramatic work by way of performance in public or otherwise. Section 2(h) defines dramatic work to include any piece of the form of which is fixed in writing or otherwise. This interpretation is both broader and progressive and can allow a singer to adapt his impromptu literary work, that is lyrics, into dramatic work by way of performance in the public or otherwise. Conventionally, copyright law does not allow a performer to claim authorship in his unfixed work. A singer can be a performer under the Act and can to a certain extent claim authorship in his or her musical work. But due to the assumption of fixation attached to a literary work, the singers tend to lose their authorship in the lyrics they created in an impromptu manner and haven't fixed in a tangible format whatsoever. But if we harmoniously construe Section 2(a)(2) with Section 2(h), we can allow such singers or any other performer to claim authorship for such literary work which has been adapted into dramatic work created via performance, apart from his or her separate right in performance. With this video comes to an end. To know more, get in touch with us via this given email ID and mobile number. Thank you for watching this video and have a nice day ahead.